Hindu marriage laws are complex and rooted in ancient traditions. They aim to create a stable family and society. One key aspect is the prohibition on Sapinda marriages. These are marriages between close blood relatives considered detrimental to family harmony and social structure. This essay explores the concept of Sapinda marriage, its legal implications, and its relevance in contemporary India. The term Sapinda literally translates to sharing the same pinda, which is a significant concept in Hindu culture. Pinda refers to the funeral rice ball offered to ancestors, symbolizing the connection between the living and the deceased. In essence, Sapindas are individuals who share a common ancestor and participate in ancestral rituals together, maintaining a bond through generations. Hindu law prohibits marriage between Sapindas to prevent unions considered incestuous and harmful to offspring, ensuring genetic diversity. The Hindu Marriage Act of 1955 codifies this prohibition, making it a legal requirement. It defines Sapinda relationships through specific generational limits on both the maternal and paternal sides, ensuring clarity. On the paternal side, the prohibition extends up to 3 generations from the father and 5 generations from the mother, creating a wide buffer. This complex system ensures a significant degree of separation between potential spouses, discouraging marriages within close-knit family circles and promoting healthier family structures. Section 5V of the Hindu Marriage Act explicitly prohibits Sapinda marriages. It states that a marriage is void if the parties are Sapindas of each other, unless permitted by their custom or usage. This provision underscores the importance of preventing marriages within close blood relations. It aims to prevent genetic disorders that can arise from such unions. More importantly, the prohibition promotes social harmony. By discouraging marriages within a limited circle, the law encourages alliances between different families and communities. This fosters social cohesion and prevents the concentration of wealth and power within a small group. The law, therefore, serves a crucial role in maintaining the social fabric of Hindu society. Section 4. Exceptions and customary practices. While the Hindu Marriage Act lays down a general prohibition on Sapinda marriages, it acknowledges the diversity of customs and practices within Hindu society. This means that the law is not rigid and can adapt to the varied traditions that exist within different Hindu communities. The Act allows for exceptions to this rule in cases where a community's custom or usage permits such marriages. These exceptions are crucial as they respect the cultural heritage and social norms of specific groups. This recognizes that certain communities may have long-standing traditions that allow for marriages within a closer degree of relationship than generally prohibited. Such traditions are often deeply rooted in the history and beliefs of the community. However, such exceptions are treated with caution. The law ensures that these exceptions do not undermine the broader principles of the Act. The burden of proving the existence of such a custom lies on the parties seeking to solemnize the marriage. They must provide clear and convincing evidence to support their claim. The courts have consistently held that any custom that runs contrary to public policy or morality cannot be upheld, even if it has been practiced for generations. This ensures that the law remains just and equitable. Section 5. Case laws and international comparisons. Several landmark judgments have shaped the interpretation of Sapinda relationships and the application of Section 5, Clause V. These judgments have provided clarity and direction in understanding the nuances of familial relationships within the context of Hindu law. For instance, in Golak Chandra Mukhopadhyay versus Mathuranath Chatterjee, the court clarified the computation of generations for determining Sapinda relationships. This case set a precedent for how courts should approach the complex task of calculating generational proximity. The case highlighted the complexities involved in applying ancient Hindu law principles to modern-day situations. It underscored the need for a nuanced understanding of both historical context and contemporary legal frameworks. Internationally, laws prohibiting marriage between close relatives are nearly universal, though the specific degrees of prohibited relationships vary. These variations reflect cultural, social, and legal differences across countries. These laws reflect a shared understanding of the potential genetic and social ramifications of such unions. Genetic counseling often plays a role in these legal frameworks, providing scientific backing to the prohibitions. The United States, for example, prohibits marriage between siblings, parents and children, aunts and nephews, and uncles and nieces. These prohibitions are enforced to prevent genetic disorders and maintain social order. These prohibitions are broadly in line with the principles underlying the Sapinda system in Hindu law. Both systems aim to regulate familial relationships to ensure the well-being of individuals and the community.